Hi everyone, welcome to the second topic. Here we're going to talk about the types of intellectual property. So we're going to talk about patents, copyrights, trademarks, and the trade secret. Okay, so at this stage, it is extremely important for us to, unlearn one big misconception, that is, that intellectual property is not one uniform right. Okay, instead, when you talk about intellectual property, it's actually a collection of legally distinct regimes, each actually designed to protect a different form of intellectual output. For example, you talk about patents. Now, patents, they protect the inventions. Copyrights, they protect the expressions, right? You talk about trademarks, they protect the brand identity. Then we have trade secrets that protect the confidential business information. So, as legal professionals, our job is not to just know these categories, but also to advise, which protection applies where, and most importantly, sometimes which protection should not be used. So let's start with the first one. I think my internet is not working. Okay. So let's start with the first one, which is the patent. So the patents are actually the strongest and most technically demanding form of IP protection. So when you talk about a patent actually grants, like an inventor, this exclusive right over a particular invention for a limited period, right? Typically it's 20 years, and in return, like when they're getting an exclusive right for an invention, the inventor has to disclose, like fully disclose the invention to the public. Now this particular disclosure function is why the patent law is central to the technological progress. For example, the pharmaceutical compounds you can talk about, or the industry machinery, the electronic devices, and even the technical processes. They are all your patent inventions, and they are given, like, the exclusive rights of the same is given to the inventor for a limited period of time. And after that, the inventor, it is mandatory for the inventor to disclose the invention to the public. Okay, so for an invention to be patentable, it must satisfy strict legal criteria. So the first one is novelty, right? Now, the invention, it must not be anticipated by the prior art. It must be new. Okay. The second one is inventive step. So obviously, it must not be obvious to a person that is skilled in that particular art or field. Then we have industry applicability. So naturally, the invention should be capable of practical use. Now here again, the courts, they, like, worldwide, they consistently emphasize these requirements, and a failure on any one of the ground, it actually invalidates the patent. So they are individual disqualifiers. They are not taken as cumulative ones. All right. Now, again, this rigorous standard, it again explains why many software based innovations, they struggle in the patent offices. Okay, now talking about the patents in the digital and AI context. So in the AI era, the patent law, it actually faces unique challenges. So, like many AI innovations, they definitely involve algorithms, mathematical models, or the abstract ideas which are traditionally excluded from patentability. Okay. Now, courts in multiple jurisdictions have actually held that your AI, it cannot be named as the inventor. Okay. So the inventorship, it requires a natural person. So again, now this would raise critical issues in AI generated inventions, especially in the automated research and the drug discovery. Okay. So let's now move to the second type of IP, which is copyright. Okay. Now, copyright is fundamentally different from patents, because your copyright, it is not about invention, it is about protection of the original expression. Okay. And it's one more thing to be noted about copyright is it's the protection of the original expression and not the underlying idea. So, like a novel idea for a story is never protected, but the written manuscript is. Okay. So, when you talk about copyright protection, the protection, it arises automatically. Like once you create it, you automatically get the protection. So, no registration is required, although the registration actually strengthens the enforcement. So, it's highly suggestive. Now, this actually makes copyright particularly important in the digital industries. Okay, now talking about copyright in digital context, copyright actually protects the software code, your digital music, films, websites, online content, and the databases. So, AI, when it comes or intersects with copyright, it complicates the copyright law. Why? Because the authorship, it traditionally, requires the human creativity. Now the courts, they are increasingly asked to decide whether the AI generated works, they qualify for the protection, and if it does, then who owns them? Is it the programmer or the user, or no one at all, right? Now these questions are still evolving at a global level. Okay, now let's come to the third IP, which is trademarks. Okay. Now, trademarks, they serve a dual purpose. First, they protect the businesses and they even protect the consumers. Okay. So, what they do is they actually identify the source of the goods or the services. And along with that, they prevent confusion in the marketplace. So, unlike your patents and copyrights, the trademarks can last for an indefinite period, like as long as they are used and renewed. So for businesses, when you talk about trademarks, they often outlive the products and the technologies. Okay, now in digital markets, the trademarks extend beyond the physical packaging. So you have domain names, application icons, platform branding, and even the virtual goods in the metaverse. They actually raise serious trademark concerns. So you will have a lot of disputes, and you still do have over the domain name squatting and the online impersonation, which are extremely common. So it all again makes the trademark enforcement a critical skill for the legal professionals. All right. Now let's talk about trade secrets. Now, trade secrets, they protect the information that derives economic value from being secret. So, unlike the patents, there is no registration in trade secret, and unlike copyright, there is no fixed term. The protection, when you talk about in trade secrets, it depends entirely on maintaining confidentiality, via contracts or policies and even the security measures. So your examples of trademark could include, sorry, trade secrets could include formulas, source codes, customer list, and the proprietary algorithms. Okay, now in the AI economy, the trade secrets are often preferred over patents. Okay, so the training data, model architecture, and optimization techniques, they are frequently kept confidential to avoid disclosure. However, again, the trade secret protection is super fragile. So once the secrecy is lost, the protection comes to an end. And this again, makes employee agreements and compliance system legally critical. Now, in practice, IP protection is very strategic. Like a single innovation may involve multiple IP rights. For example, the software protected by copyright or the algorithm that is protected as trade secret, and even the branding protected by the trademarks. So the legal professionals, they have to assess the costs, risks, enforceability, and even the objectives of the business before advising the client. Okay, so before we move ahead, let us pause here and tie this back to legal practice, because this is where a lot of we see common mistakes. So when we talk about intellectual property law, it's not about memorizing the definitions of patents, copyrights, trademarks, or trade secrets. It's about the correct classification and the strategic protection. So let's say if a client patents something that should have remained a trade secret, they lose the confidentiality forever. Or for example, if a startup it ignores the trademark protection, it risks losing its brand identity. Right. So, in the digital and AI driven economy, most innovations they do not fall neatly into one category. They sit at an intersection of multiple IP regime. So, as legal professional, our role is to understand how these rights operate together and where the law begins to struggle when the technology moves faster than legislation. So, in the next part of this module, we'll examine how the digital technology itself has started reshaping the IP protection, and why the courts and lawmakers worldwide are under pressure to rethink existing legal frameworks. So, we'll be discussing the same in the next session. Thank you so much, everyone.